our next session is the arbitration agreement. So before starting, let me brief how the arbitration proceeding actually commences. So first, there will be a contract between the parties, and they will be having a dispute resolution clause as a term in the contract, and there will be some period of time wherein they will be executing the contractual works, and after that, obviously, in most of the contracts there are disputes and there are differences between the parties. So in that case, to resolve the dispute between the parties, if there is arbitration clause in the contract, they don't need to go to court to resolve such dispute. So they can appoint an arbitrator and resolve the dispute. Since it is timely, very much significant, most of the commercial contracts offer arbitration to resolve their disputes. So this arbitration, it can be in the form of dispute resolution clause, or it can be a separate standalone arbitration agreement. So arbitration clause, it is typically a clause in the contract wherein the contracting parties, in case of any dispute, could refer the matter to arbitration and resolve it. Next is types of arbitration agreement. As I said before, it can be of uh, dispute resolution clause in the contract, or it can be a separate arbitration agreement, standalone arbitration agreement. There is another concept called as arbitration agreement incorporated by reference. Consider that you have executed an arbitration agreement, consider that you have executed a contract, and after a certain period of time, you're making another contract or some amendment to the contract. So that amendment or the superseding agreement does not have a dispute resolution clause. So in the absence of such dispute resolution clause, so the parties can refer the previous dispute resolution clause and resolve their disputes through arbitration. So such kind of um, reference is called as arbitration agreement incorporated by reference. Next is separability of arbitration agreement. So consider that you have executed a contract, and because of some terms, the contract has become invalid. And of course, if the contract becomes invalid and void, all of the terms will become void. Although the arbitration agreement could be treated as a separate term, and the invalidity of the other terms does not invalidate uh, the arbitration clause in such contract. Hence, the arbitration clause in the contract shall be treated as a distinct agreement, and the disputes which have arisen with reference to that contract could be resolved and referred to the arbitration process. So, as we discussed in our earlier session, whether arbitration agreement is discharged by death of a party, the answer is no. The arbitration agreement is not discharged by the death of the party. It can be enforced by the legal representative of such party and the company. Next is essential of arbitration agreement. We should comply to these things to make an arbitration agreement a valid one and an enforceable agreement. First, it should be of arbitration clause or separate agreement, and it can be of letters. For example, there are certain communication between the parties where it is mentioned that in case of any dispute, it can be resolved and referred to arbitration. So that kind of terms could also be considered, and it is being recognized internationally as an arbitration agreement. And the dispute obviously could be resolved through arbitration. The arbitration agreement mandatorily has to be in writing. So this rule is prevailing all over the world. Of course, it has to be in text format, black and white format. Next is valid contract. The agreement must fulfill all the essentials of a valid contract. That is, it has to be executed by the parties of sound mind and not disqualified by law, and it should have valid consideration, etc. And as Mr. Ramasubramanian sir discussed, to invoke and refer the matter to arbitration, there should be some sort of contract and dispute existing between the parties. Only then the matter can be referred for arbitration. So make sure that before invoking arbitration, there is some dispute between the parties that could not be resolved by mutual terms and negotiation and mediation. And the arbitration clause could speak on the following thing in a composed manner. For example, it should mention regarding the seat of arbitration, the procedural laws and substantial laws, and the number of arbitrators. Because if the arbitration clause does not mention regarding the number, then obviously it differs from nation to nation. If it is three, so make sure that the number of arbitrators and language of the proceedings.
Although you may switch off your camera.
Yes,
Yeah, thank you, thank you, thank you.
yes, yes. I mean, if you have any contract, um, and if you're about to execute some arbitration agreement, make sure that the number of arbitrators and language of arbitration proceedings are being well defined, because though they seem to be a simple thing, this will increase the cost of the proceeding. Because um, if it is three arbitrators, obviously the fee will be high than to the sole arbitrators. And if the agreement does not specify the language, as you know, in UAE, if it is not, if the language is not ambiguous in the agreement, it will be obviously Arabic. So the language translator has to be appointed, which is additional cost. So let us be conscious on all these terms. I mean, before signing the arbitration agreement. So, what are the challenges that we may face in drafting arbitration clause? As I said, there should be ambiguity in uh, the language of the proceedings and the governing laws and the um, jurisdiction of the uh, tribunal to adjudicate the matter, and lack of clarity on arbitrator selection process. For example, if the contract does not specify, I mean, whether it is institutional arbitration or ad hoc arbitration, then obviously it will go to court and it will become additional expenses and, of course, time consuming process. And exclusion of certain type of disputes. Make sure that while drafting arbitration clause, you mention that all kind of disputes with reference to the contract is being, I mean, could be referred to arbitration. So that kind of term will make clear that all kind of disputes with reference to the contract will be referred to arbitration, and it will not limit any sort of dispute. And absence of provisions for interim measures. For example, if the parties in between or before the commencement of arbitration proceedings, they need some interim relief. There is a provision in the arbitration, then obviously they should go with the arbitration proceeding, and they should ask the arbitrator for such interim relief. And inadequate procedures for multi-party disputes. For example, consider that there is an arbitration clause with multi-tier dispute resolution, which has negotiation, amicable settlement, mediation, and dispute adjudication boards, etc. But if the timeline is not clearly mentioned, then obviously the parties will be sitting in the mediation for about 1 year, 2 years, and 3 years, and the adjudication process will also be delaying. So we should be conscious on these terms. So multi-tier dispute resolution. Um, Multi-tier dispute resolution is something like in case of any dispute, the parties will first sit together and try to resolve their dispute by having mutual communications by either way of negotiation and mediation. As you all know, for mediation proceeding, there will be a third party who will be facilitating the parties to communicate and settle the matter. And expert determination in case of any technical disputes, the experts will be there to determine who is wrong and who is correct. So that is called as expert determination. And dispute resolution board, you might have come across this term in FIDIC contracts. So the dispute resolution board will giving an order or giving their decisions before the arbitration proceedings. And finally, arbitration. Our gentle suggestion is that in any dispute resolution clause, make sure that all these at least mediation and negotiation are being incorporated in the um, dispute resolution clause, so that the parties will have the chance to mutually sit together and resolve. Because obviously, the arbitration proceeding is little expensive than to the mediation and dispute resolution. Uh, I mean, resolving the dispute through dispute resolution board. Next is online dispute resolution. Hope you had come across this term ODR. This is one of the new procedure which is significantly capturing the people's attention now. So this is nothing but having multi-tier dispute resolution with the technical assistance. So the arbitrator with the technical assistance conducts the proceedings online, majorly online, and uh, pass the award. So the proceedings is completely similar to the normal dispute resolution, whereas the hearings will be conducted online, and the documents, whichever is has to be submitted, it will be maximum submitted online, and there is no need for any hard copy submissions. Okay. I will be displaying the dispute resolution clause for ODR and WIPO and I mean standalone arbitration agreement so that you can understand the dispute resolution clause. I mean the arbitration agreement much better. So this is an dispute resolution clause where the parties have chosen ODR to resolve their ODR platforms to resolve their disputes. Yes, sir, please.
Standalone arbitration agreement, if you have the actual agreement, you may
Yes, sir.
display. Okay, thank you.
It's there, sir. It's there, sir.
Thank you.
Okay. So here it is clearly mentioned that all disputes, that is mandatory, because if it is not mentioned as all disputes, then the party will say that the dispute resolution, the arbitration could not be invoked for this specific dispute. So there will be a different I mean conflict between the parties. So avoid that, make sure all disputes and difference of any kind whatsoever arising out of or in connection shall be disputed amicably by different informal negotiation between both the parties. However, in case of non-settlement of such dispute, the matter shall be first referred to mediation within 15 days. So this clause is very much clear on the completion of mediation proceeding within 15 days. So if it is a non-starter, if the mediation is a non-starter, so obviously the parties have to approach and appoint the arbitrator, how to approach this ODR platform and appoint the arbitrator. On the other hand, if the mediation is going on some good track, in that case, it will go on until the parties come and say that they could not resolve, could not settle in the mediation, and after that, it will go on to arbitration proceedings. So here, if the mediation is a non-starter, such dispute will be referred to an ODR platform recognized by the Ministry of Law and Justice, Government of India, who will appoint a single arbitrator and conduct the arbitration. The award of the arbitrator shall be final and binding on the parties. Obviously, the award rendered by the arbitrator is final and binding on the parties. And they have mentioned about the Arbitration Act, which is Indian Arbitration Act 1996. And here they also mentioned regarding the expenses and cost of the arbitration proceeding, which has to be equally shared by the parties in equal portion. And the language of the arbitration proceedings is being mentioned as English, and the seat and place of arbitration proceeding is Bangalore. So since it is ODR proceeding, if the party they request in that scenario, though there is an ODR clause, the parties also have, the parties also could schedule the hearing physically in some suitable places. And the Court of Bangalore will have exclusive jurisdiction for challenge and enforcement proceedings. So this is one of the typical dispute resolution clause with arbitration agreement incorporated. Here it is mentioned that any disputes, controversy, difference, or claim arising out of or relating to this contract, including the existence, validity, interpretation, performance, breach, or termination thereof, or any dispute regarding non-contractual obligation arising out of or relating to it will be referred and finally resolved by arbitration administered by the CIAC Council under the CAC rules. So this is one of the construction arbitration institution which is existing in India. So the parties here, they have mentioned that they would refer to resolve their disputes through arbitration, referring to the CAC rules. So let us see what is this arbitration clause, that is the dispute resolution clause specifically mentions. The parties agrees to resolve their disputes through arbitration here, and the law here is governed by CAAC rules. And the seat of arbitration shall be New Delhi because the CAAC office is located at New Delhi. Uh, Although the parties, if they are willing to conduct the arbitration proceeding in some mutual location, they could request the arbitrator and conduct the proceedings on the mutual location. And the number of arbitrators shall be one. Since this dispute resolution clause does not speak on the number of arbitrators, it will be one because of Indian Arbitration Act 1996. Although if it is UAE law, if the clause is silent regarding the number of arbitrators, it will be three mandatory. And the arbitrators here shall be nominated and appointed from the panel of arbitrators of CAAC, and the arbitration will be administered by CAC with its rules. The award rendered will be final and binding on both the parties. And the proceedings will be conducted in English. So this is what this arbitration clause typically says. Next is separate and standalone arbitration agreement. This is the actual arbitration separate standalone agreement. Consider that you have executed a contract. In that, the contract does not speak on dispute resolution. So after arisal of dispute, the parties are mutually willing to resolve it and adjudicate their dispute through arbitration. So in that scenario, the parties they can sit together and draft and execute the arbitration agreement. So that standalone arbitration agreement would have shall have the following terms. So let me read out that. This standalone arbitration agreement is entered between the so and so parties. By entering into this arbitration agreement, the contractor and the employer mutually and specifically agree that this arbitration agreement nullifies any contrary provisions in any other written instrument. So this clarifies that in case of any litigation proceedings mentioned in the previous contract, so that will be nullified with this arbitration, standalone arbitration agreement. And next is sorry, this arbitration agreement is not a contract of employment for any purpose. Instead, it is a standalone arbitration agreement. Generally, we do execute contract for some sort of employment or contractual works. But this arbitration, standalone arbitration agreement is exclusively to resolve the dispute. Hence, this has to be mentioned clearly in the agreement itself. And for this purpose of the agreement, covered legal claims include all claims that accrue between the contractor and the employer pursuant to the LOE, that is the contract reference for which the dispute has arisen and the parties have to resolve the dispute. So that contract reference has to be specifically mentioned. If not, this arbitration agreement would obviously become a void one. So they have mentioned regarding the appointment of arbitrator. For appointing the sole arbitrator, the parties may approach they have selected CAAC institution for the appointment of arbitrator and their respective rules. And also they have selected Arbitration and Conciliation Act 1996, which the arbitrator has to adopt and provide his award. Also, the language of arbitration proceedings is also mentioned as English, and the venue of arbitration proceeding is New Delhi here. The courts at Delhi shall have the jurisdiction to decide on the disputes, actions, and proceedings arising out of the work pursuant. So again, they have mentioned regarding the contract to make it as a clear one. And the validity of the arbitration agreement and the arbitrability of any claims under this agreement shall be determined solely and exclusively by the arbitrators. The provisions of this arbitration agreement are severable if the arbitrators decide that any of the provision in this agreement is invalid, then the remainder will be valid to the maximum extent permitted by law. So the severability clause is being mentioned in this agreement. Both the parties agree that they could cooperate and lead evidence, etc., with the arbitrators so appointed as expeditiously as possible. So they have mentioned that witness examination and other proceedings can be made as quick as possible. The parties here to agree that this reference to arbitration
Sorry, Madhu, the
the
volume has.
parties here agree that this reference to arbitration of either of the parties or sorry. Sir, can you hear me? Sir?
Yeah, I think there is some disturbance in the volume. You want me to read out?
Sir, is
I'll
it
do
okay
that.
now?
Yeah, yes, please.
Yes. The parties here to agree that this reference to arbitration would not be revoked either by death of either of the party or any other cause. So, which makes it clear that this arbitration agreement could not be invalidated by death of the arbitrator or the party or any other circumstances. So, whatever the remedies which has been sought by the parties, it has to be compulsorily adjudicated by the arbitrator. Next is if the arbitrators or any one of them are chosen under this agreement become incapacitated, yeah, if the arbitrator becomes dead or sick, then the parties, as I said before, then the parties could retain the right of nominating substitute arbitrators, and there is no need for any fresh arbitration to resolve the disputes. And the mandatory provision, that is the award rendered by the arbitrator, is binding on the parties, their legal heirs, executors, and legal representatives. Of course, whatever the award being rendered by the arbitrator, it is legally binding and enforceable by law. So here the parties, have agreed, mutually agreed, and they will be including their signature and the date and place of signature. So this makes the arbitration standalone agreement a valid one. This is WIPO arbitration clause for IP dispute. Hope you had come across this IP disputes, that is intellectual property rights disputes, that is trademarks, copyrights kind of disputes, they could be resolved by arbitration. So the WIPO, they are the parent body, they have stipulated an arbitration clause with their WIPO rules. So this is the arbitration clause by WIPO, wherein it is clearly stated that any disputes or controversy or claim arising under out of any relating to this contract and any subsequent amendment of this contract without limitation, its formalities, interpretation, etc., as well as non-contractual claims shall be referred to and finally determined by arbitration in accordance with the WIPO arbitration rules. So this makes clear that if there is such kind of contract between the parties executing the IP, sorry, intellectual property kind of work. So they have to go to the WIPO center and resolve their disputes complying with WIPO arbitration rules.
Thank you, Madhu.
Yes,
Okay. Shall we run the polls?
yes, sir.
You want me to do?
No, sir, I will do it.
Okay.
Yes, I have started the poll. It has 4 questions. You may answer it now. So out of 10, 5 have answered so far.
Okay, so let us close that because time is running out. Let me read the
So,
questions.
yeah, okay, sir.
So the first question, in the absence of an arbitration agreement, parties can refer to arbitration upon mutual agreement. Answer is yes. That is called a post-arbitration agreement. Requirement for a valid arbitration agreement. It must be in writing. It must be signed by both the parties. It must clearly indicate the intention of to arbitrate disputes, all of the above. Perfect answer. Arbitration clause survives the invalidity of contract. Yes. Even if the contract is terminated, the arbitration clause will survive. Okay. So the answer is yes. 4. Arbitration agreement can be included in which of the following forms? Separate agreement, a clause within the larger contract, an exchange of written communication, all of the above. All of the above is the correct answer. Thank you. Thanks, Madhu.